So disclosure. Disclosure is fundamental to the operation of the Family Law Act. It starts from your obligation to disclose, starts from your pre-action procedures, and it finishes when your case is complete. There's an ongoing duty in relation to disclosure. We all come across every day different types of examples of non-disclosure. A 1993 case of Suka, a case where parties had entered into some consent orders. Shortly after that, a husband applied for a redundancy, which netted him about $160,000. He hadn't disclosed to his wife prior to the consent orders being signed that he intended to apply for that, and she managed to get those consent orders overturned on the basis of non-disclosure. 2011 case of Niles and Niles. That's a case where parties entered into a BFA and some consent orders. 2 months after that, the wife sold her shares in a company and she made quite a large profit. The husband sought then to overturn that pursuant to Section 79A. In that case, the wife tried to argue that she couldn't disclose very much information really in relation to the shares because she was subject to strict requirements of confidentiality. The court didn't accept that. They said that that was no bar to her disclosing relevant information about her shareholding. In that case, the court found that the wife had acted quite fraudulently and she had failed to disclose. But they also found that the husband hadn't helped himself. What they found was that he had received advice in the lead up to signing those orders that the wife had been entering into some kind of negotiations about this, and they said you should really hold fire until to see what crystallises as a result of it, if anything. And he didn't. He signed the orders, and so the court said that they wouldn't then overturn those. Just as a little anecdote, I had a very interesting case of non-disclosure a few years ago where I acted for a wife in a matter, and her husband was a lawyer and he practiced in criminal law. We went to court originally to get her a Section 128 certificate ex parte, before we filed an affidavit on her behalf, because as part of many things, she alleged that he took substantial amount of his fees in the form of cash. She said in their home they had thousands of dollars stacked in the children's Lego container. There were thousands in the pasta jar in the pantry. There were thousands in the wardrobe in the spare room. He denied all of this, but of course she was implicated in this because she knew about it, so we got the 128 certificate. We came before Justice Watts for some interim orders in respect to spousal maintenance and interim property. And one of the things we did in that case, which harks back to something that Elaine said earlier, one of the ways you might know that someone is not disclosing assets is you look at their lifestyle. When we looked at this, that the husband's his tax returns over the last 5 years or so, he showed an average declared income of about 50 grand a year. During that time, the parties had acquired 3 properties, which they had paid off most of the mortgages, and a couple of very nice cars. And in fact, in this case, I was against John Lloyd, and John was talking about the cars, and Justice Watts at once said, Mr. Lloyd, let's just call it what it is. They're Lamborghinis. So, so in that case, you could see that there was an absolute disparity between the income that was declared and the lifestyle this couple was leading. And in that case, Justice Watts held, because the husband was arguing that he didn't have the capacity to pay a spousal maintenance order, and Justice Watts found that he did. So ordered him to pay spousal maintenance, and we got some interim property orders. But about 18 months after that, as a side note, the husband was implicated in some dealings involving some of his clients. The police raided the home, and funnily enough, they found thousands of dollars of cash in the pasta jar, in the Lego tin, and in the spare wardrobe. Not only did the couple get a very huge tax bill, but he also landed himself in jail for a period of time for that and other things as well. So that's just one example of how you might know when someone isn't disclosing. So if we think that someone's not disclosing, how can we find out more about this? Our stock standard first port of call is issuing subpoenas. And we do this because they're cheap and they're easy. That's a good way of starting our investigations. It's simple and it's cost effective. We might issue them to banks, partly because we think that someone's told us that they've got bank accounts with certain banks, but we're not entirely sure that they don't have some accounts with other banks. One of the things we often look at too are any loan documents. They're often a minefield of very good information. One of the things I often do as a barrister when I get a brief is to look at how many documents a client has signed and look at where the inconsistencies are, and loan documents are great for information on these kind of things. Another entity that's good to subpoena is the accountant, because you often get things, for example, memos in relation to meetings or file notes that again can produce some quite useful information. There's a bit of a barrier though when we're trying to find assets overseas. So it's quite easy to issue subpoenas in Australia, but if we're trying to do it overseas, next to impossible. There's service as one thing is difficult, unless it's New Zealand. Australia is a party to a Hague Convention on the service of documents, but even if you can serve the documents serve a subpoena pursuant to that convention, they're not enforceable. Essentially, when they leave your hands, it's up to someone overseas to decide whether or not they want to comply with the subpoena.